Today we're going to walk you through on how a case gets to the Supreme Court.
The Supreme Court is the highest court in the United States judicial system. It interprets national laws, resolves conflicts among states, and maintains national supremacy in law. The Supreme Court also has both original and appellate jurisdiction.
Original jurisdiction is jurisdiction of courts that hear a case first and determine the facts of the case. You have to determine whether or not the case you are presenting is a justiciable dispute. This means that to be heard, a case must be capable of being settled as a matter of law rather than on other grounds. For example, a case asking whether or not God exists could not go to court.
Another requirement to consider before presenting your case is whether or not you are standing to sue. In other words, the plaintiff has to have a serious interest in the case, which depends on whether they have sustained or are likely to sustain a direct and substantial injury from a party or an action of government. A very common type of case is a class action lawsuit. These are lawsuits that permit a small number of people to sue on behalf of a larger group.
Now to how cases get to the Supreme Court. First, the type of case has an impact on where it starts in the judicial system. Cases that involve ambassadors, diplomats, or instances where a state is a party begin directly in the Supreme Court. About 5% of the cases the court hears get to them this way. Article 3, Section 2 describes all of the cases in which the SCOTUS has original jurisdiction.
That's the most direct route. A majority of the cases heard by the SCOTUS come off of the federal route. Cases that involve a federal law are tried in federal district courts. State-level federal judicial posts are usually filled using senatorial courtesy. This is an unwritten tradition whereby nominations for state-level federal judicial posts aren't confirmed if they are opposed by a senator of the president's party from the state in which the nominee will serve.
District courts are the lowest federal courts where federal cases begin and the only federal courts in which trials are held. Another more common place where cases begin are in state trial courts, where cases involving state laws are tried.
A defendant in a state trial court or district court can appeal the decision to the next highest court. On the track of the district court route, the next step up is the Circuit Court of Appeals. For those coming from the state trial courts, they go to the appellate courts.
Courts of appeals review decisions of lower courts and hold appellate jurisdiction, meaning that they hear cases brought to them on appeal from lower courts.
Most cases that reach appellate courts are settled on the principle of stare decisis. This translates into let the decision stand, meaning that the case is to be decided in ordinance with past decisions that set a standard for how cases like this should be decided. On the federal route, the ruling in this court can be appealed to the SCOTUS. On the state route, the ruling in the appellate court is appealed to one of the 50 state Supreme Courts. This is the state's court of last resort.
Decisions in these courts can only be appealed to the Supreme Court if they raise a constitutional question. Once you appeal your case to the Supreme Court, you must prepare your petition for certiorari. This is what the court will read in order to decide whether or not they hear your case at all. This document includes the history of the case, the basic facts, and the important legal issues that your case presents.
Very few cases make it past this point. If the justices decide to hear your case, they will grant you a writ of certiorari. This is a formal document that calls up a case and it indicates that the SCOTUS will review a lower court's decision.
If the case brought to the Supreme Court involves the federal government of the U.S., the Solicitor General is called in. He or she is the person appointed to represent the United States before the SCOTUS.
Once your case has been approved for review by at least 4 of the 9 justices, the rule of 4, there are a few different things that could happen. One approach that justices may use is issuing a per curiam decision. It will resolve an immediate case but has no value as a precedent because the court doesn't offer reasoning that would guide lower courts in future decisions.
In other instances, the Supreme Court will actually review the case, the facts, and its merits in depth. A few key items are used in the review and decision-making stages. First, amicus curiae briefs are used mainly in the certiorari stage. They are legal briefs submitted by a friend of the court for the purpose of raising additional points of view. These briefs attempt to influence the court's decision. Another item the Supreme Court uses in making its decisions are precedents. These are cases in which the decision serves as a legal rule or principle that similar cases in the future should follow. For example, one of the most important cases of the SCOTUS was Marbury v. Madison. This was a landmark case in which the power of judicial review was established. Judicial review is the power of the Supreme Court to declare actions of the executive and legislative branch unconstitutional.
Petitioners will present oral arguments to the justices. After oral arguments and the initial vote, The senior justice for the majority opinion is responsible for writing an opinion. Justices will then respond by writing their own opinions. A dissenting opinion is an instance in which justices are opposed to all or part of the majority's decision. A concurring opinion is a signed opinion in which one or more members agree with the majority view, but for different reasons.
A final majority decision is eventually reached, which is a minimum of 5 justices in favor of a side. Finally, you'll receive your verdict. As this is the highest court, what they say goes. No more appealing or reversing decisions. After the final decision is made, it is written and announced to the public.
Now that you have a decision, you need to know about judicial implementation. This is how and whether your court's decision is translated into actual policy, thereby affecting behavior of others. Courts rely on other units of government to enforce their decisions.
If your case made it all the way to the Supreme Court, you are most likely going to want the justices to exercise judicial activism, the philosophy that the Supreme Court should play an active role in making policy decisions. An active judge will make bolder decisions and make decisions that are more personal or politically based, which may be in your favor.
Something that may be less in your favor is if the judges tend to be more judicially restrained. This is a judicial policy in which judges play minimal policy-making roles, leaving that duty strictly to legislators. These judges are less active and limit the amount of power they use. They hesitate to act or strike down laws unless they are an obvious violation of the Constitution.
By following these simple steps, tips, and information, getting your case to the Supreme Court should be no problem.